Hello and welcome to the new series of Drishti IAS. I am Pooja, and in this segment today we are going to discuss about handcuffing in India. What is the protocol? What is the principle suggesting not only Indian but worldwide? What is the directive or set of guidelines that have been given by the Supreme Court which pertains to handcuffing, the position of it in India? And in the last of the segment, we will discuss about the important possibilities or solutions, and of course the conclusion with the question that we have for today. So what is the entire segment about? It is all about these particular points. GS mains paper 2 is the most one to be concerned about, apart from preliminary facts that are important. So what is the issue? The Karnataka High Court has given certain directives by awarding 2 lakh rupees as compensation for handcuffing of an accused, because this was done illegally without any cause that should have been registered in the police diary by the police, but the delinquent police officer did not do so, so this award came into being. The liberty has been given to the state, that is the state machinery, to recover the compensation amount by the delinquent police officer. The name of the case is Supriteshwar Divate versus State of Karnataka. So this is the entire issue that we are going to discuss here. So what are the principles that are, of course, encompassing the issues with respect to such inhumane act? That is, it is kind of a blot on a democracy when somebody is handcuffed until and unless they are proven guilty, innocent until proven guilty. So Universal Declaration of Human Rights 1948, it talks about the general liberty, equality and freedom of a human being, and handcuffing is something that is against the dignity of any individual. The inherent, this is missing an I, the inherent dignity of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. Article 1 says that all humans are born free and equal in dignity and rights, and Article 3 says that the right to life, liberty and security of a person shall be preserved. Article 5 says that no one shall be subjected to torture or cruel or inhumane or degrading treatment or punishment. This is we are talking about with respect to handcuffing over here. Article 11A says the presumption of innocence of a person charged with penal offence until proven guilty. Okay, International Covenant on Civil and Political Rights of 1966, Article 7 says no one shall be subjected to torture or to cruel, inhumane or degrading treatment or punishment, and Article 10 says persons who are deprived of their liberty, they shall be treated with humanity and respect. Okay, for the inherent dignity of the human person, and the accused person shall, save in exceptional circumstances, be segregated from convicted persons. That means until and unless one person is guilty of doing something, we cannot treat them as guilty. And of course, the accused and the convict, they should be segregated with respect to any inhumane or degrading treatment. So here in India, in the Indian polity, under normal circumstances, there is no need for handcuff to be there on a person, and it shouldn't be done until and unless there is a high chance of exceptional circumstances coming into fore, that is possibility of escape and or possibility of causing harm to himself or others as well. And the reasons should be recorded by the arresting officer in the diary, police diary, and then that will be scrutinized by the judiciary. So this particular case was against a person who was charged of certain issues or certain acts under Negotiable Instruments Act 1881 for the dishonor of checks, and this was a non-bailable warrant issued by the magistrate. So until and unless a person is proven guilty, how can we handcuff that person? So what are the circumstances under which a person can be handcuffed? These are 3 circumstances in which a person can be legally handcuffed. An accused on his arrest and before he is produced before the magistrate, an under trial prisoner during transit from jail to the court. In case manpower is less and the manpower is not heavy enough to prevent the person from escaping, this can be done. A convict being transported from jail to the court and back. These are the 3 circumstances. And a National Crime Record Bureau report of 2020, Crimes in India 2020, says that 810 cases of prisoner escape from police custody were registered against 931 in the year 2020, and no less than 117 cases were registered against negligent police officers as well. So this is in absolute terms, it won't look a very big number, but it is a number that could impact the policy making with respect to it. So there are certain guidelines which were provided by the Supreme Court in the Prem Shankar Shukla versus Delhi administration case of 1980, in which the apex court said that the only circumstance which validates the incapacitation by irons, that means handcuffing a person so that the person's capabilities are reduced, an extreme measure, the apex court also said that it is an extreme measure, is that otherwise there is no other reasonable way of preventing his escape. That means if security is not prevalent enough, if the security with respect to provision of manpower is not heavy enough, then handcuffing can take place. This is also an extreme measure. Okay, so a person, an accused basically, shall be prevented and has to be prevented from escape by increasing security. If one increases security, there is no need to handcuff. Now in 1995, the apex court said that minimal freedom of movement cannot be cut down by application of handcuffs or other hoops. Handcuffing of prisoners without judicial consent was illegal because this is kind of a slap in the face of Article 14, right to equality. Until and unless there is a segregation between accused and convict, this is right to equality first, right to freedom, and then Article 21, right to life and liberty, life with dignity basically. Moving on, if we talk about the next thing, in the Ravikant S. Patil case, it was stated by the Supreme Court that the authorities concerned may, if they think necessary, they can hold an inquiry against a person, against a delinquent officer, and then decide an action against the police inspector. This is against the police inspectors who had certain malified reasons to handcuff a person. So in this Ravikant S. Patil case, it was said the police authorities, whoever the authorities may be, they can also form an inquiry and take action against the police inspector. Moving on, compensation, if we talk about, currently the Karnataka High Court has put the onus on the police officer, the stated police officer, to compensate the accused, but this is an established principle that the relief monetary compensation this is also by the High Court. The very important thing here is whatever we are saying is with respect to judiciary. This is not what we are producing. It is an established principle that the relief of monetary compensation for an established infringement of the fundamental rights guaranteed under Article 21 of the Constitution is a remedy available in public law, which is based on the strict liability for contravention of guaranteed basic and indefeasible rights of the citizen. That means in order to preserve the Article 21, there is a principle that relief of monetary compensation would be there. And the Bombay High Court in the state of Maharashtra versus Ravikant S. Patil said it stated that the inspector of police should give 10,000 as compensation to the accused. But the Supreme Court said that the police officer was not personally liable because he was working in capacity of the state, in professional capacity as an instrument of the state. So because of this, the person should not be liable, but the state should be liable. So basically it said that the state machinery is ultimately responsible for compensation. Okay, so state's responsibility, if we talk about the solution, state's responsibility should be there to equip all police stations in order to maintain proper security so that handcuffing doesn't take place. And if there is a lack of manpower or urgent law and order duties, then increment of manpower can also be provided for a contractual basis. We can also put a body language analyst, which can predict the conduct of an arrestee on the spot so that a decision can be made up. It would also be appropriate for state governments to review the mobility of the police. Surveillance can be taken, such as putting body cameras on the police. That is done in many countries, especially in the US as well, so that the conduct of the arrested and the arrestee both can be taken into consideration. Okay, this was also recommended by the Karnataka High Court. But the biggest thing is that guidelines have already been provided. So the lower courts, the onus is on the lower courts and the police authorities to ensure that these guidelines are abided by and not just washed away. So look at the question. discuss the criticisms of handcuffings of under trials in the Indian polity in 250 words. That's it for today. Tomorrow we shall meet again. Until then, stay updated. Thank you so much for watching.